Alex here with a legal nuts and bolts video on early case termination. It's just this catch-all phrase I've decided to create because I wanted to create a follow-up video to the videos, the complaint and the answer. If you haven't seen the videos, the complaint and the answer, there's two different videos. One's called the complaint, one's called the answer. Please stop this video and watch those two videos in order. This video will make a lot more sense to you if you watch those videos. If you can recall, I've also done videos on the technical stuff that I'm about to talk about in this video. I'm going to mention that as I go through this video. So anyway, I'm just going to go into it. Those two videos cover the sort of opening up of the case. And again, this isn't going to be like, I'm going to use ordinary, I'm going to try to use ordinary sort of examples and analogies to explain my understanding as to how all this works, and hopefully it helps ordinary people that are not attorneys understand this, because I'm not an attorney, so maybe that's just something that I'm better at doing than attorneys. I don't know. I hope so. I really hope these videos help you guys, because sometimes they can get pretty crazy in the technical sense, and I worry about that. But anyway, in the complaint, I talk about how that's kind of setting up. It's like opening up a box and putting in all the things that the court's going to look into. The issues go in there, the targets go in there. And by targets, I mean people, business entities, etc. The answer is very similar in the sense that it is clarifying for the court what those particular issues are going to be, because that's what the answer addresses. It admits and denies certain things, and it's going to set forth, it's like acknowledging or responding to the person who set forth the boundaries of the case. So this video goes into the topic of ending cases early. What I mean by that is not going all the way to trial. And I think that one of the things that ordinary people struggle with is they don't understand that at different parts of the process, there are different purposes that are satisfied. Most of the time, an ordinary person thinks they're fighting the whole case the whole time all the way through, and they're not. That's not how it works. So most people who are completely ignorant, they know the concept of a jury trial. And they know the concept of a hearing. Most people have seen Judge Judy and the People's Court, so they know what a hearing looks like on TV. And most people know the concepts like beyond a reasonable doubt and jury trial. And they know what those things are, and they might have an idea as to how they look. But what most people don't know is, how do you get there? You don't just automatically get that jury trial sort of situation just because you want one. And early case termination is the way that cases are defeated without going to trial. They're defeated because there's no point of even going to trial. Now, that's a concept that I know a lot of people struggle with. They think that the Constitution says they have a right to a trial, and, well, you do if there's a point to the trial. You have to show that there's a point. Now, a lot of people think that this isn't fair because it's your right. But at the same time, I think it helps, at least it helped me. It helped me to understand that I was using up all these other people's time to have to deal with my case. And I hope it helps my viewers to understand the same thing. If you're going to have any kind of litigation in court, you're using up a bunch of people's time. Attorneys, they're getting paid, admittedly. The court, which is getting paid, but I'm not sure that they're getting paid what they can for thousands of cases that they process. And then if it's a jury trial, this is where it's really, in my opinion, egregious if you waste a juror's time, because they are paid, from my understanding, it's not even close to what it is to lose a day's worth of work. I haven't looked at the exact dollar amount, but if you're asking for a jury trial, you should really take a step back and think, is this case legitimate? And I'm not saying in the sense of my issue is not important to society because it's only like $20. I'm not trying to talk in the sense of the value of your case. I'm trying to talk about it in the sense of the effort that you're going to put into your case to put on a presentation that's worthy of their time. So whether it's like a $10 million thing or a dispute over $2,000, it's a question of you having to put in a tremendous amount of work to sort of justify all of these people coming into the courthouse and listening to you. I feel like that is valid. I feel like society and the government and even the Constitution, it's a valid request to expect you, who is bringing stuff to court, to actually put a tremendous amount of effort into showing that there's even a point to going to a trial. Too many people, I think, don't look at it this way, and they think they're just entitled to it and therefore they should have one. And it's not like that. You can't just roll out of bed, walk into court, talk, and expect to be. It's not fair to everyone involved. So early case termination is a series of mechanisms that are available to attorneys to shut cases down. Well, not just attorneys, even to you as a non-attorney, to shut cases down quickly without going to trial. And a lot of times, if you're a non-attorney and you're going into court and you're representing yourself and you don't know what's going on, most likely this is what's going to destroy your case. It's one of these various different mechanisms. So I'm not going to talk about each of the mechanisms because I already have separate videos on those topics anyway. I will talk very briefly about them, and then I would recommend, if you want to learn more about it, to go in and watch that separate video on that particular topic. And then, of course, you can always look at statutes, rules, and case law. And then there's videos from attorneys on YouTube who are fabulous and go into all kinds of technical stuff that I'm just not going to go into. I'm just trying to get people to understand the sort of general idea as to why all of this stuff is happening. You know, when you go in and you don't know what's going on, it can feel very unfair. But once you start to understand the point behind everything, it makes sense. And even though it still doesn't feel quite as fair because you're not an attorney and you haven't done this 1,000 times, at least you understand the meaning behind why they're doing stuff. At least it doesn't seem like a completely alien concept to you. So the first one is the motion to dismiss. I think it's shorthand for motion to dismiss for failure to state a claim upon which relief can be granted. It's a bunch of words, but the point of it, again, watch my video on the topic motion to dismiss. The point of it is to attack the complaint or the petition if somebody's filed that. If you remember, if you watch the video of the complaint, you'll see that it sets forth the targets to the lawsuit and the issues. The purpose of the motion to complain isn't even to get into any of the proof or any of the who's right and who's wrong. It's just looking at the complaint only. That's all. That's the one target of that specific mechanism. And that mechanism is picking through the complaint and it's saying, this case should be thrown out because even if everything in this complaint is true, you still aren't entitled to relief. Now, there's some exceptions to that, and I talk about that in the video motion to dismiss. But when I'm talking about everything, in quotation marks, I'm talking about specifically allegations. So sometimes people will put in something in a complaint, like they'll state something that's conclusory. That stuff is just ignored by the court. They'll decide that later if you even get to a trial. But they're looking at your allegations. You know, if you're alleging certain things, and those allegations aren't enough to satisfy the elements of a particular cause of action. So like, let's say you sue somebody for fraud. Well, fraud has like certain elements to it that you have to prove. But in the complaint, you have to at least allege them. If you haven't even alleged them in the complaint, like maybe you're missing one of them, or maybe you're not alleging it with sufficient particularity or something like that, then somebody can say, we should just throw this case out. This person hasn't even alleged element number 3 of fraud. If I'm not even being accused of something, why are we going to bring all these people into court and have a trial? You have to at least accuse me of it. And so that's what they're doing with the motion to dismiss. They're attacking the complaint or the petition, and they're saying that the allegations in here aren't sufficient. And they can use that partially too. They don't have to throw the whole case out. Sometimes you'll bring like 5 causes of action, and they might say we want to dismiss causes number 2, 4, and 5 because those allegations aren't good enough. There's also other quirky things that they can use to sometimes get around your allegations. So sometimes you'll have allegations that are good, but maybe statute of limitations has expired or something like that. And so they'll say, well, these are true and they do satisfy fraud, but look, here's this law that says that they should have brought that within 2 years and it's too late now. So it's still the same thing. It's just a sort of offhanded ninjutsu sort of way that they did it. Same thing with not complying with statutes. Sometimes there's like you try to do like a professional malpractice, something like for like doctor, medical malpractice, stuff like that. So there's like specific laws that say when you sue someone for that, you have to add an affidavit from an expert or something like. So there's sometimes weird requirements that are specific to certain types of causes of action, and they'll say, well, okay, you've alleged everything you needed to, but you didn't comply with a specific law that the legislature passed, and they said you need to, put the affidavit in the complaint. And you forgot to do that, or you didn't get one, or whatever. So there's also people, like you may have alleged everything correctly, and you just targeted the wrong person. Somebody will say, hey, dismiss this with respect to me, because I didn't do that. Somebody else hit their car, not me. So anyway, that's what you're dealing with the motion to dismiss. It's specifically targeting the complaint and only the complaint. Too often people will look at that and they think that the whole case is on the line now. No, it's not the whole case. It's just that one piece of paper that's setting forth the boundaries of the case. And then there's a few others I'll talk about. So there's one called motion for judgment on the pleadings. That takes a case out early because the answer admits certain things. So let's say the complaint alleges 5 or 6 different things, and the answer, they admit them. I know it sounds weird, but it's happened. It's rare. If somebody's admitting everything, you can just do a motion for judgment on the pleadings. You don't have to get a jury in the courtroom and all that stuff. You can just say, hey, look, I accused them of doing 7 things and they admitted them. Can I just get my judgment now? Yeah, you can. If you want to learn more about that, watch the video on the topic motions for judgment on the pleadings. I think those are the 2 main ones that they use. And I believe, if I remember correctly, that a motion for judgment on the pleadings, the answer has to be filed. Otherwise, I mean, there's only a pleading, singular. There's no plural pleadings there. And then for motion to dismiss, if I remember correctly, that's one of those quirky things that they can do without answering. So they can just they can attack your pleading, your complaint, and they don't even have to have an answer on file yet. But if I remember correctly, there's all kinds of stuff in the rules of civil procedure as to how it works, and I think that after it's denied, then they have to file an answer at some point in time after that. And people have asked me, people who have done this before, obviously, and have some experience, they've said, hey, how come you get to amend the complaint? Shouldn't it just, it's not fair. Why should you get to, it's targeting the complaint. The motion to dismiss is targeting the complaint. So it's reasonable for the system to say, yeah, go ahead and add the things that are missing from the complaint. I mean, it's kind of a cheesy move to allow cases to be thrown out because of technicalities. That's what ordinary people view it as, a technicality. When ordinary people say, hey, this case didn't go to trial because some sentences were missing, they forgot to allege something, most people don't like that. It doesn't sound like a fair justice system. So yes, oftentimes somebody will file a motion to dismiss and the judge will agree and they'll say, yeah, there's some allegations in here that you need to, they have to be in here, or you're not, accusing them of enough stuff. Now, that's not the opportunity to start lying and bringing up accusations that aren't true, but it is legitimate that sometimes people just didn't forget to mention a specific thing. And so the court system has that mechanism where they'll let you amend your complaint to include the parts that are missing so that the case can proceed. You just have to sort of understand the point of the process to really understand why they do these things. Otherwise, it just seems like it's cheatsy or unfair or strange to you. If you watch the complaint and then you watch the answer and then you finish watching this video, hopefully you'll have an idea as to what the whole point of the pleadings phase is. You're just kind of setting up a scaffolding, like a wireframe. Nothing's going to get fleshed out until later. And so, I mean, that's the whole point of that beginning process. Is there even a case to even spend any time on? There's also really weird things that are available in unique circumstances. One of them is the anti-SLAPP special motion to dismiss. And I say it's weird because I'm not sure that I've ever seen anything else like it. I think this is the only thing out there that operates in this way, and it's because of the Constitution. It's because of the First Amendment. The right to free speech is so powerful that they created a special mechanism that allows somebody to force the court to look seriously at the First Amendment principles very quickly and to crush cases out immediately. It has to do with finances and all kinds of, I'm going to use the word evil, but evil tactics that some companies and people used in the old days, which was to sue people when you knew you couldn't win. But you just sue them anyway, just to scare them because they're poor and they don't have any money, and make them just shut up. Anyway, I have a video on the topic. I think it's called anti-SLAPP motions. Finally, I can get past that portion to the other portion. There's a middle phase, the discovery phase. And once your case survives the beginning, the pleadings, everything's fine. The pleadings look good. There's some claims that can go forward on. Then you go through all the research and stuff, and that's the discovery phase. Please watch my video on the topic discovery. In that video, there is, it branches out into 5 or 6 different videos. There's all these different discovery tools, which I won't talk about, but watch that video and it'll mention all the different tools, and you can watch those videos on top of that and learn the discovery process. But this is the time when motions for summary judgment start popping up. And those are the motions that are also trying to kill a case early on, trying to terminate your case very early on, or your case, or if you're the other side, their case, or whatever. If you're just observing, you just want to learn how it works, the case. Those work differently. Those are, they seem to have a dual purpose. On the one hand, in a way, it sort of attacks your failure to do enough to get to the bottom of what sorts of issues that are going to be decided by the jury or the judge if it's a bench trial. And what I mean by that is there is a responsibility on the person bringing claims to do some work to find out what kind of evidence is going to be brought up at the trial. A lot of people think that the point of the trial, because they've watched Judge Judy and the People's Court, this is why they think that. They think that the point of the trial is to bring all the evidence up. But really, with normal formal court systems, it's more the presentation. It's like the PowerPoint. The stuff that's going to get addressed is brought up before, and that's brought up during the discovery phase. And there's all these different tools that people use to force the other side to answer certain questions, to force the other side to produce certain documents. Also, subpoenas get issued to third parties that aren't involved in the lawsuit, which orders them to turn over documents. Depositions are done, which is a way to question witnesses before going to trial. And so there is sort of this onus on the person who's suing to really gather all this stuff up. And that is attacked at the summary judgment phase if you don't do enough. Like, you have to do the research to find out where all the lines are, because there's boundaries and technical details that I'm not going to talk about. There's just too much research to do on your own for that. But I'm just trying to explain the point of it. If you just like skate through the process and you don't even try, I've seen people file motions for summary judgment saying that there's no issues for the jury to decide or the judge to decide. The other side hasn't asked for anything, or they haven't asked for enough, or they maybe have gotten a few things out in discovery, but those particular things really don't create any issues of material fact for the jury or the judge to decide. And so what they're trying to say is we should just decide these now, summarily, without going to an evidentiary hearing or a trial. They're trying to kill the case now because they're saying there just aren't any issues that really need to be discussed at a trial. And since there aren't, the court should just decide these issues now. Now, that doesn't always mean it's going to work out in that particular person's favor, because sometimes there's pure questions of law that have no facts, or there's questions of law where the facts have been decided that actually are still in favor of the plaintiff. It happens sometimes. Sometimes there's just nothing for the court to decide at a trial, and it backfires on the defendant because the court's like, yeah, based on the law, the plaintiff does win. So it's rare, but it does happen. And then there's the other sort of side of the summary judgment coin, which is that you thoroughly have done all of the discovery you possibly could do, and that based on the things that have come up, maybe the evidence that's come up, that the depositions that have been done, that they're, for whatever reason, looking at all that stuff, all that evidence, there isn't actually something that's genuinely there, that there's like a dispute. Because sometimes there are issues of material fact that aren't in dispute. There's all kinds of quirks. So like I was trying to say, it's another mechanism to terminate a case early. It's a lot more complicated than the other ones because it involves the process of finding all the evidence, and it involves the process of determining what is in conflict, what is there for a jury or a judge to decide, to weigh the pros and cons of what is there that's contradicting something else that needs a fact finder. So if you want to learn more about that, please watch my video on the topic motions for summary judgment. The only other thing that I guess I can mention in closing that terminates a case early is default. If you want to learn more about default, watch the video default. That's typically just that the other side just didn't answer the lawsuit. Since they didn't answer it, you just win automatically by default. Watch that video, I explain more. And then the other thing is case terminating sanctions. So sometimes somebody just does not participate fairly in the discovery process. And so the court says, since you aren't participating fairly, you just lose as your punishment. Like, shame on you. Now, since we can't get through discovery because you're not playing ball, we're going to just go ahead and terminate the case early, just like we wanted. But you lose. So if you want to learn more about that, watch the video on the topic compelling discovery. I think I'll talk about case terminating sanctions in that video. So just so you guys know, this is a video that I'm hoping people watch after the complaint and after the answer, and hopefully it helps people understand why there's all these different mechanisms in place to terminate cases early. It's there to save people time. It's there to save people stress. It's there to save people money. It's there to make it so that the person who is suing has done all of the work that they're expected to do to really earn that right to a trial, especially if there's a jury. You really want to earn that right to force those strangers, because it's not just 12. You get a whole, like, there's this process called jury selection. They bring in like 50, 60, 70 people. That's a lot of people that have to come in and listen to a person, and to have them waste their time over, you know, a particular litigant who just didn't do anything at all and just wants to talk to them. That's really messed up. And so the system has all these mechanisms in place to force you to do all of the work to show, number one, you actually have brought a case, and number two, you have, you know, you've done your due diligence, you've done your job to gather up all the evidence that you possibly can to put forth a presentation. That's the key word, because once you get to the trial, it's a presentation. If you want to learn more about what I'm talking about there, watch the video on the topic trial format, and even more importantly, trial format revisited. I hope that this makes sense to people. I hope that my viewers agree with me. I mean, if I was a juror, I would be annoyed if I went into court and I had to sit in the juror's box and somebody didn't do any work at all and it was a sloppy case. I wouldn't mind doing my job as a citizen of this country under the Constitution to go in and sit, you know, on a jury and be a juror. But you have to at least try. You have to at least bring a real case that has real issues. Nobody wants to go in there for something frivolous. That's not cool. And if you don't agree with me, let me know down in the comments. But that's my feeling. I mean, you're talking to the person who didn't even ask his parents for money to litigate my child custody case. That's how bad. I felt so bad about asking my own family for $5,000 for an attorney retainer that I represented myself. I don't like to waste other people's time. It's a sensitive thing for me. And so my view of this whole early case termination thing is very in line with that sort of idea, that before you burden other people with these particular issues, that you at least go above and beyond to put the best presentation on you possibly can for them. Anyway, I'm going to go ahead and end this video now. If you have any questions, feel free to post them down in the comments below, and I will see you guys next time.